Hey, there's a saying that a wise man speaks with few words. These are the little things that are done that makes all the difference when it comes to a lot of things in life, but even more specifically, when you begin to do things of this nature. A lot of people feel the need to funnel and demonstrate their frustration, their knowledge, or how they feel through paper. While that is okay if you're writing love letters, when it comes to the enforcement of law doesn't care about how you feel. And anyone on the other end, regardless of whether they are peons or whether they know what they're talking about, if it gets in front of them, they couldn't care any less about how you feel. Ever so often would you read people's papers and they will go on and on, page after page, about their feelings. What do I mean by feelings? Feelings are good, feelings are necessary. But the angle and perspective most people come from, especially those who have newly found that, okay, there are laws out here that actually benefits me, and it has not been used to my benefit, so I have to be hasty and do something. What you will find often with them is there's a very bad foundation. Because of that bad foundation, most of the things they all stumble upon are certain types of templates. Those templates constitute two main things: a lot of codes and statutes and a lot of case laws. There's hierarchies, steps, and degrees to things. And one of the things you will face first when it comes to what you think you're doing and how powerful you think it is you would just dump a lot of codes and statute, 18 USC 241, 242, 42 USC 1982, even though 42 USC is not positive law. And because of that, it's really not enforceable by you. If you're saying you have rights and you're one of the people, you better find something else similar to 42 USC or something much stronger than that. Nonetheless, a lot of people put a lot of 18 USC codes and violation and monetary damages and all that. Say you're a defendant in a case. I see this way too often. Say you're a defendant in a case, you start putting a lot of violation and fee schedule and all this. Do you not know in order for you to enforce that, you need to do a counterclaim? You need to come as a plaintiff? You putting a lot of monetary damage and fee schedule is not going to scare anything or anyone. It's in fact going to let them know that you have no idea what you're doing. Because if those amounts that you put in on those pieces of paper are truly enforceable, the role that you're playing in that venue as a defendant would have switched, and you would have known how to do it. And there's no need for you to scare someone and say, hey, look, I'm going to sue you now. I'm going to sue you. You don't have to do that. Give them due notice. Simple as that. A lot of people think due notice is listing statute after statute after statute, case laws after case laws. See those case laws you're all listing? Those things get overturned and overruled very easily. Most of the time when you use certain case laws, there have been other case laws that has overruled that, but are kept silent until it is used against you. Only then would you notice, oh, all these case laws that I'm finding in all these websites on the internet have been overturned. Or these case laws are not even by appeals court. The appeals courts, based on the hierarchies of court at North America, makes the final determination of the judicial decisions. And even then, it's still not admissible, because the privilege that a British accreditation register member have, you don't have it because you're not amicus curiae. You're not a friend of the court. So you merely citing some case law is not sufficient for it to be admissible. You would have to get that order within that specific case and put it in through judicial notice or admit it into evidence one way or the other. There are many ways to admit evidence outside of judicial notice. Make it self-authenticating. If you're not doing that, you're wasting paper, you're wasting time, and you're making a fool of yourself. All those statutes, 18 USC 241, 242 you're listing, all of those are copyrighted material by Westlaw. Westlaw and a lot of other companies, and a lot of attorney limited partnerships, and a lot of congressmen and congresswomen have copyrighted those statutes that you are citing. But unless you get permission to use those statutes, it has no standing or capacity, and it is not enforceable. So when you start to list all this codes about monetary damage and about what can be done and what cannot be done, they're not going to tell you that you cannot enforce it because you're not a party to the ownership of that statute. What they're going to do is make you look stupid and say, hey, your papers are frivolous. Then you get upset and you wonder what's going on. The least you can do if you want to use a copyrighted property is to get a copyleft. Look it up. Look up the word copyleft. Simply a permission by someone who's a copyright holder granted unto another party to use a specific thing. You don't have a copyleft, all those statutes you're listing are useless. And guess what? When they got a hold of certain things, is they realized that, and by they I'm referring to anyone with monetary, socioeconomic interest in the public's ignorance. It can be your next door neighbor, it can be your friend, it can be your father who belongs to some order that you have no idea about. It can be a politician, who knows? It can be an acting judge. Whoever has interest in the ignorance of the public people is not liable to tell you these things. What they're going to do is just shun you and push you to the side, because they have also been the one to put all these templates out here, whether you know it or not, for you to use, and you stumble upon it because you're reading it and you're looking at the verbiage and you're going, this sounds good, this makes sense, I got them. No, you don't. You don't even have the foundation to understand what it is you're using. Someone has to be honest with you. You really want remedy, you really want some true recourse against whoever your tortfeasor is, you really want relief from whatever it is that's strangling you energetically, monetarily, financially, economically, socially, judicially, administratively, then you need to go back to the foundation. Know about what you're using. Those codes and statutes you're using displaces your substantive right that you're saying that you have, because it's not yours. It doesn't belong to you. It's not your property, and you don't have permission to use it. And besides, the Constitution only guarantees you a right based on the legislative acts of Congress. Codes and statutes, read it. They're just compilation of law. They're not laws themselves. So what you need to find is the equivalent of that code and statutes and use it. The original version that the Congress has passed. It will be public law, public act, general law, general act, so and so. A statute at large, so and so. Not USC 18 subsection 241. 18 USC subsection 242. Once you start putting that on paper and you think you're doing something, they're going to do a Faretta hearing on you. They're going to put a British accreditation register member on you and just steamroll you. They will cook you. They will steam you up real good. They will eat you and shit you out. All those case laws you're using, if you yourself have yet to read the order within that specific case, the exact verbiage, the exact circumstance that led to those decisions, how do you really know the circumstance deals with you? You merely reading some quote somewhere online doesn't really mean that's what the case is about. Most of these case laws people quote over and over. They don't read the actual case. They don't read the docket. They don't read the order. They don't read the circumstance that led to that decision. But they just throw it on a piece of paper and think it just works in magic. It doesn't work like that. To them, all you're doing is crying. That's exactly what they want you to do. You think you have fangs. You think you're really making some noise. You think you're really scaring someone. You get all excited and giddy because they sent you a letter with a heading of their official office. And you think they're taking you serious. But at the end, deep down, you know they're not. The simpler your paperwork is, the stronger it is. The less you cite case laws, the stronger your documents and your rights are being enforced. Because your individual, your specific circumstance that you're dealing with is yours and yours alone. And the burden of proof is on them to show that other situations are similar to it that will bar you in one way or the other. You create your stare decisis by coming in right. The moment you start using other stare decisis, the best it can do for you is limit your rights based on that thing that you're making reference to. Why would you want to do that? Use the Constitution and the treaties directly. Use the Public Act and the public law directly. Work the dynamics of your own circumstance and create your own reality. Stop dumping case laws that's not by appellate courts or case laws that's been long overruled. Stop dumping it into a piece of paper and think it's going to make things work for you. It's the quickest way for them to identify you as a sovereign citizen because they know you don't know what you're doing. You are on one hand saying that they're using statutory law on you. They're using man-made law. So it doesn't apply to you. So they don't have jurisdiction. Yet, here you are listing 18 USC. USC this, USC that. Same statutory things that they're using against you, you want to use against them. What don't you get? No wonder they're very comfortable doing all this BS. No wonder they're comfortable tampering the evidence with the confidence that you're not going to do anything with it. Because you allow them to. Because of your greed and your haste. Someone has to be honest with you. This is not to tear you down. This is to get you on the right track. Because you're lost in the sauce. Things that you're doing now is going to affect the future generations. Believe it or not, they are stacking a whole lot of res judicata and stare decisis based on what you're doing now, just so it could be used against your children in the future. If only you had any idea the severity of what is going on now that's being planned to be used against you. Stop and slow down with all this trash you keep putting out. Case laws after case laws, just copying and pasting it on a piece of paper. Stop that crap. It does nothing. What you ought to do though is take those case laws, study them, and apply the foundational principles, dynamics of it. Put it to use. Don't just cite it and think it's going to do some magic for you. It doesn't work like that. The use of stare decisis and res judicata, that's not how it works. You have to prove yourself competent. Merely citing some case law does not show that you know what's going on. Merely citing some case law does not prove that you know what your rights are, or what it entails, or how it's enforced, or how you can fend off any trespassers of that substantive right. And being able to enforce your substantive right has absolutely nothing to do with how much you can talk or how sophisticated you sound.